Good afternoon, this is Sean Golding with Golding & Golding, here to go through the basics of FBAR litigation, foreign bank and financial account reporting. There's been some recent cases that have come down recently, so FBAR litigation has been on the mind of many who have foreign accounts that may not have reported it timely due to some technicalities involving the form itself. Litigating is different than if you're litigating a regular tax. Let's go through the basics. The FBAR, foreign bank and financial account reporting. It's technically filed on a FinCEN Form 114 Financial Crimes Enforcement Network, but 99% of the time, FBAR has nothing to do with criminal per se, so don't let anyone fearmonger you based on that sort of title. It's not an IRS form, but since 2003, the IRS is tasked with enforcement. The form is used to report a whole host of different types of foreign bank and financial accounts. It's not just bank accounts. Bank accounts is in the name, so oftentimes people just think it's bank accounts, but it's investment accounts, mutual funds, CCOVs, foreign pension, life insurance that have surrender values or certain cash values, things like that. So it's all different types. Important thing to remember, it has nothing to do with tax per se. So what that means is you may not have to file a tax return because you don't have reportable income. You may have accounts that don't generate any income or generate income and it's not distributed, et cetera, whatever different flavor it falls into, whatever category. It's not a tax, so it's not a tax form, and it doesn't matter whether you have to file a tax return as to whether you have to file it. It just matters whether or not you're a U.S. person. So when you're talking about the FBAR, what will happen, someone will get dinged with some penalties. What do? Well, hopefully it's pre-assessed versus post-assessed. Once they're post-assessed, fighting it could be a little more difficult at the IRS level because you've already been assessed an amount. If it's pre-assessed penalties, then it's not set in stone yet. It's easier to try to negotiate, try to mitigate. Once penalties are assessed, then the agent has more work to do. The examiner has more work to do, go back and change it and fix it and reduce it, and they have to get their supervisor's approval, like in anything, right? If it hasn't been assessed yet, then it's easier to try to show mitigating factors and try to stop it from the outset. So normally what will happen is you get dinged with some penalties or not, and finally the penalties hit. If it's pre-assessed and it doesn't work in your favor, you go through the appeals process. It doesn't work out, right? The IRS doesn't like you and they want to hit you with a bunch of penalties. You want to go to tax court, right? Because tax court, you don't have to pay anything up front. But unfortunately, the FBAR is not a tax. The reason why that's so important is because then you can't take your FBAR matter to tax court. Instead, you have to go to federal court, court of claims, which is, adult court, they used to say, as opposed to tax court, where oftentimes a taxpayer goes in there. They don't even have to be represented. Plenty of taxpayers have gone in on their own and come out with wonderful results, okay? So what happens when you want to litigate the FBAR? Well, one recent ruling came down in a case called Mendu, which was great for taxpayers. See, the reason why people like to go to tax court is because you don't have to pay it up front. With federal court tax matters, typically you have to pay the tax, the penalty, the amount due up front, claim a refund and then go in and sue the U.S. government. That's the FBAR rule. But in the case of Mendu, the court said, hey, no, that's not going to work. You can't not let a taxpayer go to tax court where they get the opportunity to fight it without putting it up front, and now require them to go to federal court and require them to do full payment. It's like a sword and shield, right? On the tax court level, the government's saying, hey, it's not a tax, so you can't go to tax court. They can't turn around and then try to use it as a sword and say, well, you have to file first because it's a tax matter, right? You have to pay first, because it's a tax matter. So that's a great decision. So you may not have to pay it up front in order to go to federal court. There's conflicting circuits, and there's two main cases. It's Bittner and Boyd. Boyd is in the 9th Circuit. It's taxpayer-friendly. Bittner is in the 5th Circuit. Not so much. And Boyd basically said non-willful penalties in a situation in which accurate FBARs are filed. Subsequently, it's limited to $10,000 per year. That adjusts for inflation and is a 6-year max, right? So that's a lot of money, but if you have a lot of money overseas, then that may not be as bad as Bittner, in which the court directly contradicts Boyd, even in the ruling, and basically says, no, we can get you $10,000 per account per year. So generally it's up to 50%. It's not to exceed willful penalties. That's not from the ruling as much as just the way it goes. And you can read about it in the Internal Revenue Manual. But so someone could literally have like 40 accounts, right, with a whole bunch of money in it, and they can get dinged for a lot of penalties. So when you're going to federal court, you want to kind of consider what circuit you're in and what the potential outcome may be. What a lot of people will do is before they get dinged with penalties, there's various what's called amnesty programs. Depending on whether you're willful or you're non-willful, there's different programs that you can apply to. Some of the more common programs, well, voluntary disclosure, VDP, is primarily for taxpayers who are willful or just can't certify under penalty of perjury that they're non-willful. It was a little different under OVDP, which is a specific offshoot for the voluntary disclosure program. Now it's a little bit different. You generally would only do that program if you're willful. There's various non-willful programs. There's the streamlined filing compliance procedures, which are then broken down more into streamlined domestic and streamlined foreign, and then there's reasonable cause and delinquency procedures. We have lots of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate and something that we handle. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.